You know what, direct contempt of court is,
to
sir?
put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
We're playing by my rules, not yours. So you know, do not say anything because you're going to figure that out real soon.
There is nothing more annoying for a judge than a sovereign citizen who thinks the law doesn't apply to them. Luckily, they're always masterfully taken down as soon as they step out of line. From unfounded claims to masterful shutdowns, this is when arrogant sovereign citizens mess with the wrong judge. And let's start things off with a man so convinced he could outsmart the law that he forgot the judges always have the final say. Meet Jonathan Schuster, a Washington resident facing several DUI charges, driving with a suspended license, and failure to appear. Normally, this would only be a misdemeanor, and the process should be fairly simple. But he made it clear from the very first moment that he would use every single sovereign citizen move in the book to make things difficult.
My honor. So for the record, I've made this special dissertation under duress pertaining to the matters of Jonathan Troy, Faifoleaso Schuster. For I am beneficiary, I am sovereign, I am man. The flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris in propria persona. I reserve all rights. I do not understand the status, and so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
To summarize all of what he said, he denied being a US citizen, tried to alienate himself from the charges, and questioned the judge's authority all in less than a minute. The judge tried her best to go along with it as she explained his situation, but Schuster just kept on being as arrogant as possible.
Jurisdiction cannot be proven unless status is established. You have not established status, and so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody.
Jurisdiction cannot be proven. I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again,
laws.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency.
Any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is because my rights have been violated. And if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date.
As a surprise to everyone, Schuster came back to court for his secondary hearing. However, it did not take long before he let the new judge know it would go exactly as the first one.
For the record, Abigail, this man was never appointed to me on my behalf. Like I told him the very first time I've ever met him, I'm here sui juris in propria persona. I reserve all rights. Jonathan Troy Faifoleaso Schuster. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered.
But little did he know, this new judge wouldn't be so understanding of his strategy.
You cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
He's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr. Schuster?
Please do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back on July 1st.
Are you threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't show up.
So me now.
I'm giving you the choice of showing up or a bench warrant
issue. The choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you
gonna,
like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
if you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more
giving
so
you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed.
So for the record,
For the
the
record.
defendant's choosing to leave without his paperwork. He is expected to be back in court July 1st at 9 a.m.
Following a few other online hearings, Schuster came back to the courtroom to make his final stand, just before being issued his final warning.
Schuster, if you choose not to come to your court hearings, a warrant will issue for your
And you're
arrest.
threatening me again, telling me
Yes,
if I don't.
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
Mr. Schuster, you are in a criminal court and there are court rules. If you wish
Criminal
to
matter,
have,
this is a criminal matter, you said?
Mr. Schuster,
This is a criminal matter?
if you wish to have discovery, then you need to abide by
You
the
said it's
rules.
a criminal matter?
Yes, and if you wish
Yes,
to have,
these are-
Oh, okay. I wasn't sure you said that. And so since you guys are gonna waste everybody's time even more, goodbye.
Mr.
Mr. Schuster, you need to sign for your court dates. I'm giving them to you orally.
Have a good day. Talofa.
If you don't appear for your court hearings that were given today, a warrant will issue.
I'm sure everyone agrees that he should have been charged with contempt, obstruction, and fleeing justice immediately. However, he was only held for his original DUI charges, for which he was found guilty. The same can't be said for Bozeman native Ernie Tertelta, who only lasted a few minutes before paying for his arrogance. Tertelta sits before the court facing charges for obstructing a peace officer and resisting arrest after he was caught fishing without a license and refused to surrender his catch.
Mr. Tertelta has been charged with 2 misdemeanor offenses, which we'll be trying today.
I must object. I am not the name that he is referring to. I am the living man.
In his defense, Tertelta claimed to be a natural man, and that he had the right to forage any foods he deemed fit whenever hungry, a practice just as ancient as his outfit. One right he does not wish to employ, however, is that to remain silent, and the judge had to remind him there were rules to follow in modern days.
Mr. Tertelta, you are not to interrupt Mr. Riley again.
Ma'am?
He has his 30 minutes. Then you will have.
Who can tell the living man
Mr. Tertelta,
in a commercial event such as this,
sir,
who has the right to tell the living man when he can speak and when he cannot speak, what sounds he can make and what sounds he cannot make?
I'm going to hold you with contempt if you continue to disrupt this.
Ma'am, without oath and bond, contempt has already been established here.
30 days in jail, or you will be removed.
In the
from
face of
courtroom.
all these witnesses, ma'am, where is the evidence of oath and bond, ma'am?
Cannot talk.
Look,
Now, do you continue to disrupt?
As he kept blabbering about ancient legislature and made it impossible for the judge to continue with the trial, she made the decision to get rid of the problem straight from the source.
I cannot, ma'am, in honor of the Constitution of the United States, I cannot allow a man who carries British recognition for the purposes of British ministerial law to continue to persecute me. I cannot, ma'am. I have to honor the founders, ma'am. I honor the memory of those who fought and died that we could be free of this very type of thing.
You'll be taken up to the jury room where you may watch the proceedings.
Stand up.
I have reminded you.
If I stand up, I give you recognition.
Please stand up.
All right.
Stand up.
No,
Stand up.
pick me up. I cannot give you recognition. I'm constrained by the United States Constitution of 1789. Sir, you're a Bozeman native. What are you doing packing a British recognition? Should be ashamed of yourself.
Once he was escorted out of the courtroom, the trial was able to continue, and the jury found him guilty on all charges. He didn't have to spend time in jail, but did have to pay over $400 in fines. On the other hand, this next sovereign citizen had to be held down to even stay inside the courtroom. We're in Santa Cruz County, and 37-year-old Shannon Marie Blackshire is arriving at her sentencing hearing.
This is the date and time set for sentencing. The records show the presence of the defendant. Our advisory council is here.
You might wonder why she's being escorted in by her own entourage of bailiffs. Well, to start, she's been charged with breaking into several homes within the community, and tried claiming that she had been awarded the properties by the federal government. Following her arrest, Blackshire dismissed 2 different attorneys and insisted on representing herself, only to refuse to show up for several hearings and trials. But But just because she finally stepped foot inside the court doesn't mean she is willing to comply with common procedures.
Is your true name and your complete name Shannon Marie Blackshire?
The court lacked jurisdiction over the subject matter.
What is your date of birth?
The court lacked jurisdiction over the subject matter.
The court will accept the court, based upon a verdict by the guilty in this case.
The court lacked jurisdiction over personal addiction.
As a result of a jury trial, the court finds the defendant is guilty in CR 22209.
As the judge kept reading the charges, Blackshire decided she did not want to be there anymore, so she had to be reminded that she was in no position to take charge.
This is in violation of ARS 28624C,
Y'all cannot force me to get sentenced.
Yes, I can. ARS 28622, ARS 28622.01, A1, 28624C, 283001, 283304, 283305, 283315, 13701, 702, and 801.
No matter how much she objected, the trial carried on its course, as both the judge and the prosecutor ignored her sovereign script.
And if the victims wish to be heard, we have victims here in the courtroom. A victim, I think, I'm not sure.
No, Your Honor, she's outlasted the victims.
She's outlasted the victim. Do you wish to be heard?
The victims have had to return back to their homes in Oregon, and they're not here, which is a detriment to them. They had as much a right to be here as she did for sentencing, but she is her own attorney, and she's drugged us out long enough that the victims aren't here to give a statement today.
You're not? Okay.
But I don't want to be in here.
Stay in.
To leave.
Oh, you're bringing the chair in. Okay, that's fine. I apologize, Mr.
That's fine, Your Honor.
I was getting signals from the defendant.
That's fine.
All right. Defendant is back. You may continue, Mr. Wang.
Thank you, Your Honor. I would also point out to the court that count one, the unlawful flight from law enforcement.
After her second entrance, she was lenient enough to remain quiet for the final sentencing, probably because the next step would have involved duct tape.
So the total sentence as to count one, classified felony, is 3.5 years. The total the total sentence for count four is 5.5 years.
In total, Blackshire was sentenced to 7 years in prison following a jury trial. And I'm certain she won't be walking away from that one. Not all judges are as understanding of sovereign nonsense happening in their courtrooms. And this guy found out the hard way he had just messed with the wrong judge. We're in Porter County, Indiana, and Judge Michael Fish is holding a first arraignment hearing. The defendant is Michael Aligretti, who faces multiple serious drug trafficking charges following a local narcotics investigation. Given the severity of the charges, the judge had to make sure he really wanted to represent himself, not knowing how obnoxious the sovereign defense could get.
I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr. Aligretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No,
and you will have counsel. I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Well, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire counsel.
I will not be accepting that, Your Honor.
It seems like this wasn't Judge Fish's first rodeo with a sovereign citizen, and he knew exactly what was next on the script.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? You know what direct contempt of court is, sir?
Yes.
What Aligretti did not know was that the judge had already lost all patience with him.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
But that doesn't mean he did not keep making things harder for himself.
Because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
that
not
they would
understand.
file. What did you not understand? The words I used or what they mean?
Before the hearing, Aligretti sent countless claims to employ his state's sovereign rights, but they were all promptly dismissed.
What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedures of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know why?
If you just let me finish.
Because it doesn't follow the rules of court procedure. And
I'm in equity, Your Honor.
Going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter.
If that wasn't already enough, it seems like he was suffering from selective amnesia.
Let's go through the charges again. I had an initial hearing with you. Let me see when I had the initial hearing. Back on November 3rd, 2025. And at that hearing, I went through all the charges with you. And I made sure at that hearing that you understood all 3 charges that were filed against you. And you acknowledged each and every time I went through a charge that you understood both the charge that's alleged against you and the potential penalty for that charge. You not recall that hearing, sir?
I recall the hearing, but I still don't understand the charges of the natures or the proceeding.
So Judge Fish gave him something he is sure to remember.
All right, sir. Do you understand the allegations in count 1?
No, I do not.
Related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me, what do you not understand?
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Aligretti, is find that you've unduly delayed these proceedings.
All I want to
find you in direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Honor,
contempt.
I have a job.
Please take Mr. Aligretti into custody.
As a result of his lack of understanding, Mr. Aligretti was charged with contempt and spent the night in jail, and was appointed an actual attorney who knows how law works for all further hearings. And things just get far less predictable when these sovereign citizens aren't bound by the courtroom, just like it did for Robert Matson, who's facing an online hearing on charges for drug possession and child abuse following a probation violation. It did not take long before Matson demanded to represent himself, all while obstructing the procedure as much as possible.
I don't think you'd be violating your oath of office, Your Honor, by allowing me to the right to a fighting clause.
Sir, I didn't ask you about any of that. I asked you if you understand.
I will, however,
Mr. Matson, don't interrupt me. The question I asked you is whether you understand that you have the right to be represented by an attorney.
I do understand I have a right to be represented by an attorney. Or not.
He might not want an attorney to fight for him, but he does not seem to mind having one as a personal assistant.
Due to my means here and having access to certain things and paperwork, I will use your court-appointed attorneys just to help with some paperwork.
Okay, so you don't have a right to have the public defender's office do your paperwork or handle any of that. You have the right to have them represent you or not represent you. So that is your choice.
Not represent me, that's fine then.
Despite more wild requests, the judge proceeded with scheduling the upcoming sentencing hearing, after using a special weapon, of course.
We will have you back in person on
Hold up then. So if I'm not entitled to a trial to determine if I'm guilty or not, this is a criminal court, isn't it?
It's a criminal court where you have already pled guilty to a felony and been placed on probation.
Because I was at risk of dying in this.
I've muted Mr. Matson's device because he continues to interrupt me and not let me finish what I'm saying.
Matson's next appearance had an even worse start, but the judge already knew how to handle the situation.
Yeah, Judge, I think the court is making a big mistake here.
I appreciate that, Mr. Matson. And we've discussed it before.
Any of my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the jurisdiction. I've never signed anything to
Mr. Matson, if you don't stop talking, I'm going to your device, okay? I've discussed all of these issues with you before.
Okay.
And
well, I object, but I'm Mr. Matson, that's what you're
all
doing.
right. I've muted Mr. Matson's device because he won't stop interrupting me.
What no one could have predicted was that he decided to absent himself from the hearing to go to a doctor's appointment.
Do that, but you have pled guilty in this case. I think under normal circumstances, that would be an adequate recommendation with...
Judge, I just spoke with a female at the number that he gave me, and she claims that he is at a heart doctor appointment at this time.
Even after they managed to contact him again, he kept violating procedure like he was on a call with friends.
Everyone back with us now. Mr. Matson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood. All right, I'm going to ask you to remove your hood also, Mr. Matson.
Matson was later sentenced to 18 months in prison for the child abuse charges and 12 months for the possession charges. Surprisingly, the judge was kind enough not to hold him in contempt. The same can't be said when Judge Cedric Simpson had the pleasure of giving sovereign citizens what they deserve. Representing himself in the Michigan District Court is Taric Day, charged with felony fleeing after getting caught speeding. He thought he would get a better chance at evading an actual sentence if he employed the sovereign defense. But from the moment Day opened his mouth, Judge Simpson knew he would have a field day at schooling someone who had no idea what he was talking about.
Sir, you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
Just like clockwork, he jumped straight into the next step of the sovereign script, but he gave it a unique spin.
There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant, stating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
Having a hard time understanding why.
I will commend him for learning all the terms by memory. Too bad he faced a judge who was extremely more knowledgeable than he was.
Religion does not play a role in what I do or what this court does. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the government should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No, sir, what you're about to state is incorrect.
Well,
if you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
It is. And the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules. You are subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
As Day kept obstructing procedure, Judge Simpson's patience kept running thin, until he had to issue a final warning.
Young man, you're going to figure out something. We're playing by my rules, not yours. So you do not say anything, because you're going to figure that out real soon.
He might not have gotten any extra jail time for his behavior, but that encounter with Judge Simpson was less than enough. Now, the easiest question anyone can be asked inside a courtroom is their name. And this next man could have saved himself a lot of trouble if he did. He might not state it for the court, but his name is Matthew Aldridge, a sovereign citizen from Cheatham County, Tennessee, facing several drug possession and sale charges, resisting arrest, and minor traffic infractions. He might think that sticking to the sovereign strategy would get him out of it, but the judge was ready to swat every single one of his attempts.
Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
His authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name?
Instead of wasting his energy following along with his delusions, he decided to use them against him.
All right. Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation.
Things did not stop there, though, and the judge kept explaining what would happen if the real Matthew Aldridge did not show up to the hearing.
Is that an Article 3 trial?
To what?
Would that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. When I'm talking, you stop talking. You're wasting the court's time by doing this. And I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case.
The hearing had to be postponed, but not without a final call for Aldridge to come out of hiding if he did not want to make things worse.
To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get his card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will take place with him in jail, incarcerated on the 15th.
Due to the severity of the charges and Aldridge's stance during his hearings, he was found to be at flight risk and had his bond set to $16,500. Hopefully, his self-appointed attorney was able to post it. The sovereign citizen movement is by no means a new phenomenon, and it is the older members who go on to be the most obnoxious and arrogant ones of them all. A clear example of this is 85-year-old former New Hampshire State Representative Dick Marple. Marple is being charged with driving with no license, but he chose to turn what should have been a simple hearing into a standoff.
Madam Magistrate. Yes. I am here under threat, duress, and coercion. I'm not here because of an order, because you as a magistrate cannot make an order. You can only administer ministerial duties. You have no jurisdiction to judge your own jurisdiction. I'll give you the citations on it.
A regular person would probably be convinced by his speech, but the judge wasn't about to be intimidated by someone screaming his nonsensical beliefs over her.
All right, well, Mr. Marple, what I'd first like to say in response is that you were provided 2 full hearings on your issues of jurisdiction.
You have no jurisdiction, and I'm going to read the judgments. This one is dated April 12, 2017, which says,
the entire hearing consisted of the judge explaining the current actual law to Marple while he kept interrupting and citing his own ancient interpretations of the law.
I considered everything in my 2 previous orders where I denied jurisdiction. I understand that you still dispute jurisdiction, and the process under the Constitution when someone does that is to follow the appeal process. You will have an absolute right to appeal my decision.
You have no decision because you don't have any jurisdiction. I'm going to read into the records, if there is such a record.
Let me just finish. February
28th.
Once he realized his statements weren't having the effect he hoped for, he turned to a more aggressive strategy and pictured himself as the victim.
I ask you to recuse yourself from this because there's sufficient evidence to show your animosity toward me and spreading this out to justify the salaries that are being paid to these corp employees. Are you going to recuse yourself? I ask you that.
I am not going to recuse
You're not going to recuse yourself.
And let me put my reasons on the record. Please, again, I just ask for the courtesy of doing that.
he does make a compelling case. I mean, every citizen has the right to drive with an unregistered piece of paper in place of an actual driving license.
Prosecutor over here delivered what was purportedly a license. It's not a license. It is a photo ID that I purchased.
All right, well, that is...
I've asked for it 4 times. You refuse to give it to me.
Well,
that's conversion.
All right.
That is conversion. Criminal conversion.
Mr. Marple?
Following continued slander from part of Marple, the judge decided to wrap things up and left to deliberate on the sentencing.
The automobile is a consumer good. As she walks out and is defeated by being the first one to leave the battleground.
I really don't think Marple won the battle, let alone the war, given the fact that he received a judgment of guilt through the mail and had to pay a $310 fine and restitution for the traffic charges. This next guy only hopped on the sovereign train to try and waive his charges, but chose the wrong judge to practice his new ideology. Samuel Purdue was attending an online hearing while facing several charges, including parking tickets as a repeat offender and speeding, which are misdemeanors, but could land him up to a year in jail. Now, most sovereign citizens avoid acknowledging the charges, but Mr. Purdue here got straight to building his defense.
I'm assuming you're going to plead not guilty to both of those?
No, of course not. I'm innocent, and my name is not Mr. Purdue, so I would appreciate if you didn't call me.
What he didn't expect was that the judge was ready with his own counterattack.
Mr. Marple, let me tell you this. Stop. Yeah, you're from some alternate universe where you don't have to obey the laws of
No,
the
you
state.
don't respect the law, sir.
Stop. If you drive again here in St. Joe County, I'm going to set your butt at $10,000.
That should have been enough for anyone to keep quiet, but he just kept on making things harder for himself.
Lied to you. You see this? Are you looking? I was forced to get this license. I don't want it, but as you can see, your officer is a liar.
Well, what's the name on that? Is that Samuel Purdue or Mr. Morrow Bay?
Well, I'm forced to do this. Anything I do with y'all is under threat, duress, and coercion.
So
every time I travel, clearly,
all right,
one of your commercial mercenaries keep pulling me over.
You have a driver's license?
Because your commercial mercenaries continue to pull me over, and they won't leave me alone.
Well, stop driving. At least stay out of
I don't drive.
But let me make this
that's
clear.
What I'm doing, and they won't let me travel. They won't let me travel on my own land. And you're violating the law, and you know it.
Whenever facing traffic violations, it's common for sovereign citizens to state that they don't drive, but instead travel as an attempted loophole. And judges don't like this one bit.
Well, you're behind the wheel of a car, give me this BS about traveling versus driving. I'm just telling you right now, you heard it here. If you drive again in St. Joseph County and you get another ticket, I'm going to set a very high bond. You can sit in jail for 28 days until we sort this out.
No matter how many complaints are thrown around, the judge will always have the final say.
So any judge who does not comply with this oath of office to the Constitution of the United States wars against the Constitution and engages in acts...
All right, I'm going to mute your microphone. I don't want to hear this crazy... nonsensical thing.
At the end of the day, Purdue would only face his original charges as the trial moved on, and was lucky enough to not have to spend an extra month behind bars. And whatever this next arrogant sovereign citizen's plan was, it got shut down just as quickly as it began. We're back in Michigan for what should be a quick procedure. Christopher Renfro represents himself against 2 civil infractions and 1 misdemeanor. I say it should be quick if it wasn't for Renfro immediately challenging the court and the validity of the charges.
My name is Christopher Allen Renfro. Today I am demanding a vacate of these matters for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America.
Despite his best efforts to make his case, it wasn't enough to convince the judge, mainly because none of it made any sense.
That's my statement. I demand the court to vacate these matters and restore me whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. proper term would be dismissed, but denying that request.
As the hearing kept going, the judge took it upon herself to use every opportunity to teach Renfro why his claims were unfounded and to mock his sovereign script.
Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So, is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended, commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. If, again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to the King of England.
Luckily for him, the only punishment he got was the public humiliation for his attempted defense, although he did choose to keep representing himself for the jury trial, so I'm sure nothing good came from that. No matter how passionately sovereign citizens recite their scripts, they always fail to find success in beating modern law and common sense. If you want to see more courtroom cases, one cop was sentenced to a lifetime in jail for trying to cover up his crimes, and a judge was glad to fire an officer for undermining her authority. So hit the like button, subscribe, and click on this video to see 10 times judges saved his people from corrupt cops.